Hello and welcome back to our YouTube channel. Well, it is lecture number 25 of Indian Polity today, and the date is 10th July 2025. Well, before we'll start our discussion, let me give you the brief introduction about the initiative so that if you are new to our channel, you will get more connected with us. From 2nd June, we had started an initiative here by the name Target IAS 2026. Under this initiative, every day we upload two videos, and the aim of uploading these two videos is that we can cover your both current affairs as well as your static part. So in the first video we discuss your current affairs, we discuss the daily news analysis, and we upload it in the morning session, and we do the detailed analysis of your current affairs there. And in the evening session, which is this video, we upload another video where we discuss this static syllabus of yours. And we started with Indian Polity. Right now it is the 25th lecture of Indian Polity, and here we had promised you that by the month of January 2026 we are going to complete your full syllabus, whether it would be related to your prelims or mains. We will try our best to complete everything in this time span. And also, as we are delivering the lectures here, we are preparing notes for you guys. These notes are very much different from your conventional ones, because after every topic which we discuss there, we bring up the questions related to those topics, whether related to prelims, if it is important for your mains, then related to mains also, so that when you are reading these notes, you will get the idea how these topics are important for you and you will not skip them. So this is the idea behind it. And if you want to get the service of these notes, you just have to mail us, and we will respond. Then you will have to pay 200 rupees per subject. It is totally optional. If you want to avail the service, then only. Otherwise you can watch the videos and get satisfied with it. So this is the brief introduction about this initiative. If you want to be the part of it, please do subscribe the channel, do share it with your friends, and please do write in the comments what else should we bring for you guys. Now, without any delay, let's start our discussion where we left yesterday. We are discussing the center-state relations, and I told you that in our previous class that in the center-state relations, here in the Indian polity, we will mostly discuss with respect to the legislative relations, and we will discuss the administrative relations. So these two aspects we will discuss. And yesterday's class, it was much related to your prelims preparation, and today's class, I guess 50% of it would be related to your prelims preparation, and after that we will discuss the mains perspective of this discussion. So today we are going to discuss what are the administrative relations between the center and the state. So we'll start our discussion on the administrative relations. With respect to the administrative relations, or we can say executive relations, it is very much important for you to understand one thing. The executive powers lies with the at the union, executive powers lies with the president, and at the state, executive powers lies with the governor. So what is it? How do you need to understand it? For example, let's suppose tomorrow, the center, they are coming up with the law related to citizenship. Let us suppose they came up with the law related to citizenship, and they want to implement it. Can they implement it anywhere in the country? Yes, 100% they can implement it anywhere in the country without any opposition from the states. They can argue, but they cannot oppose. Once the law is passed, once it is passed, it is formed, then nobody can oppose. Kashmir cannot say that you cannot implement it for example, Kashmir is not a state right now. Suppose Punjab cannot say that you cannot implement it in Punjab, because whatever law is, whatever executive order the parliament makes, whatever the executive order, whatever the administrative order the parliament makes, it is binding on every state if they want it to be like that. For example, related to citizenship. So with respect to this, what is the idea here? The idea is the obligation of the state. The idea is the obligation. It is the obligation of the state to implement it is the obligation of the state to implement the order of the executive or from the center to implement the laws formed to implement the laws formed formed by the center. It is the obligation of the states to implement them in their particular territories. They cannot oppose them. If they will start opposing the citizenship amendment bill, for example act, it has been, if they are opposing this law, what will happen? It will be assumed that they are violating the constitution, and then what will happen? There would be the president's rule. So this is the obligation, this is the relation, the superiority the center enjoys. Can the same superiority state enjoy with respect to center? No. The answer to it is big no. Center cannot, state cannot do the same. They cannot they cannot make a law which will implement it in at the center level. This cannot happen, but center can definitely do that. So this is what how it is understood, that it is the obligation of the state to accept the law and implement it in their particular territories. Similarly, I will give you the another example. There was 26/11 attack happened in the Mumbai attacks in in Mumbai. By the name suggests, everybody would be very much aware of that. When these attacks happened, there was no centralized agency. There was no centralized agency at that time. So what was the case? Different organizations were coordinating between. The police was coordinating with other coastal guards. So there was coordination between various organizations. So various organizations were involved in it. Then what happened? There were loopholes with respect to our administrative control. So what the center decided then? The center decided that we will bring up the agency NIA, and this NIA will deal with all terrorism related cases. And this is the central agency. What NIA is? It is the central agency. And also we have the police at the state level. They also deal with the they also can deal with the terrorist related cases. So let's suppose tomorrow the NIA wants to interfere. There is some recently Pahalgam attack happened, and now NIA wants to investigate into the Kashmir. Again, I'm forgetting that Kashmir is UT now. Let's suppose it was the state and NIA wanted to intervene there. Can the Kashmir police stop them? No, they cannot stop them, because they don't have this authority. NIA has the authority to investigate the matter. They can interfere with the police, and police cannot do anything there. So this is the centralized, this is the centralized characteristics of our federalism. This is the superiority the center enjoys with respect to the administrative control. It is the obligation of the state to accept it. So this is what this is what the center-state relationship is defined by showing that the center is the superior and the states are have to accept them. States cannot dictate them. Center can dictate them in a very specific way. For that we have, you would have heard about Article 265. Article 265. Do you know what this Article 265 says? The Article 265, it deals with center can issue directives to the states. What? Under Article 265, center can issue directives to the state, and these directives are coercive in nature. Like the states have to accept these directives. For example, tomorrow, center would want to bring in any other agency, and it is for example, states, directives are of two types. For example, first, the center will say that you should do that, and it will not have that much legality over the state. The state may accept or not. But if the center thinks that state has to accept it, and it is the matter of very importance, it is the matter of importance, it is the matter of national interest, then this center will give the directive through Article 265. Then at that time, state at any cost will have to accept that directive without any delay. So this is what Article 265 says. This is what defines the relation between the center and the state. Now, with respect to the center state relations, it is not all about it. We have to understand every concept with respect to it, how center state relationship is in a way cooperative sometimes, how it is forced sometimes, and at the same time we will see other aspects of it too. Let me rub the board first, then we will go to the other important points with respect to it, which are very much important for your prelims preparation. So where we reached to article 265 here. Directive is given under article 265. So let me tell you what it is about, what it is actually. Suppose there is some issue in any state. Let's take the example of Punjab. There are some terrorist activities going on there. So center will, by the help of NIA, will try to intervene there, but the police is not allowing them to interfere, or CBI is not allowing them to interfere, or the police is not allowing CBI to interfere, or any other agency, or there is allegations of corruption, so ED is not allowed to intervene there. So what will center do? Center will give directives through article 265. Once these directives are given through article 265, then what it becomes? It becomes mandatory. It becomes mandatory for the state to let them to cooperate with the center at that time. If the state will reject it, then what will happen? It will be assumed that state is violating the constitution, and it will be assumed, it can be done that the president's rule will be imposed in that particular state. So this is the importance of article 265. Similarly, we have this cooperative federalism also. We have the it defined the overall concept of the center state relationship with respect to the administrative control. It showed where center stands and where state stands with respect to this relationship. Now let's have a look at it. It is not all about it. These are things which are at the extreme points, but there is also the cooperation. So let's see what is the cooperative federalism between the center and the state. Let's have a look at the cooperative federalism between center and the state. Cooperative federalism. If we look at this cooperative federalism, this we had borrowed from the Australian Constitution. The main aim of this cooperative federalism is that there should be a trust. There should be trust between center and state. There should be trust between center and state, so that we can develop together. We can, if the states develop, that means the center is developing. If the states develop, that means the country is developing. So for this development, there definitely is the need of the trust between the center and the state. So for that, there are few articles. For example, we have article 258 and article 258 clause A. These articles, article 258 clause A, it was added by the 7th Constitutional Amendment Act. Through these articles, we get the best understanding of the cooperative federalism. So what is this? What is this cooperative federalism? For example, center has to, there are talks that census would be conducted from 2026 onwards. So once the census would be conducted, census comes under which list? It comes under the union list. So it is the duty of the center to conduct the census. But would it be easy for the center? Would it be easy for the center to conduct the census on its own without the cooperation of the states? Would it be easy for the central administration to do it throughout the India? No, practically it would not be easy. So what they will do? They will, contact, they may contact under Article 258. They may contact president. Will get the consent of the governor and delegate some powers to the governor. What president will do under Article 258? Under Article 258, president will consult governor, will contact governor, and by contacting governor, it means that by the consultation of the state government there. And once they will contact the governor, and then the president will delegate some powers to state. So what does it mean? That center is saying here that we have this duty, this is our power to conduct the census, but for some time being, you as a state, I trust you, I know how much trustworthy you are, I know how much honest you are, I know how much you believe in the equity. So I'm trusting you to do this census exercise in your state on my behalf. So this can be done under Article 258, and it shows the cooperative federalism which is in our Indian Constitution, which our India believes in, which our democracy believes in. So this is Article 258. Now, can the states also do it? can can states can the state governor consult president with by the contact president by the consultation of the parliament, that you can then delegate some state powers to the center. Yes, and the president can the governor can do so. And under which article? It is under article 258A clause A, 258 clause A. And I told you it was introduced by the 7th Constitutional Amendment Act. So center can also do it, and the state can also do it. So there is the cooperative federalism. There is this cooperative federalism between the center and the state. Now similarly, there is the forced delegation too. This is the cooperative federalism. Now there is the forced delegation too. Now let's have a look at the what is this. Here we saw that there was the cooperative federalism, cooperative delegation, that center would ask the president would ask the governor, and then governor will consult the council of ministers and he will agree. And then similarly governor would ask president, and president will consult the parliament, then they will agree. So this was the cooperative delegation. Now in this way, in the cooperative federalism, there is one term also, one type of delegation, which is the forced delegation, under which if the center will say that you have to do this exercise, then there no is not the option available to the states. States have to do it. What is that called? That is called the forced delegation. And this forced delegation, it is not done by the president. Please know the difference. It is done by the parliament. It is directly done by the parliament. So parliament will approach the state government, and states and can force the state, and states cannot say no. Can states force the parliament? The answer to it is big no. States can't do same. The parliament can force states, but states can't force the parliament. So this is the cooperative federalism. So in this way, similarly, in the cooperative federalism, there are various issues too. For example, you would have, there are various issues in our state. For example, there are various interwater disputes, interwater river disputes. There are huge disputes related to water. For example, Karnataka and Tamil Nadu. There are water disputes. So with respect to these water disputes, who are going to adjudicate the matter? Who is going to adjudicate this matter? Who is going to solve these issues? So how will center come into this picture? For example, there are disputes between two states with respect to the water. Karnataka with respect to Karnataka and Tamil Nadu. So what will happen in this state in the interstate river water disputes? Let's see what will happen in interstate river water disputes. This interstate river water dispute, it is highlighted under Article 262 of Indian Constitution. So under this Article 262 of the Indian Constitution, what Parliament can do? Parliament can enact law and adjudicate interstate river dispute, and adjudicate interstate river dispute. So if there is any river dispute in any particular area, then the parliament can make law and adjudicate interstate water dispute. So in this adjudication, what the parliament has done, it also in this what the constitution had done, it also excluded it excluded the jurisdiction of the Supreme Court. So here it is the parliament will act as a judiciary, quasi judiciary here, that it will enact a law and adjudicate interstate river disputes. So in this way, how the parliament will do it? First parliament will go for the negotiations between the two states. Listen, what are the issues with you? What is the issue with the Karnataka and the Tamil Nadu? How much water do you need? They will go for the negotiations. If the negotiations will not happen there, then what will they do? They will set the tribunals. They will set the tribunals, And for each case, for example, there is case with the Kaveri river, then there would be tribunal related to Kaveri river. So for each case there they will set up the tribunal, and the decision of the tribunal will be final. It can, the decision of the tribunal will be final. Ideally it should have not been ideally the Supreme Court would have been away from it, but we are seeing the cases, we are seeing that often the interstate water disputes are heard by the Supreme Court. What is the reason for that? The reason is, first, the Supreme Court says that we don't have the original jurisdiction in it. We don't have the original jurisdiction, but we have the appellate jurisdiction. What is that? For example, the tribunal will give its judgment. The tribunal will give the final judgment. Then the Supreme Court, they have the power to review it. We have the judicial review, which is the basic structure of the constitution. The Supreme Court will review it. And also this water dispute, it is the matter of livelihood for the people. It is not only about the states. It is not just a political matter, but it is also the matter of the livelihood of the people. People are people are very much dependent on it. Their livelihood is dependent on it. So definitely, to rescue the people there, then the Supreme Court will have to come into the picture. So these are the reasons, why Supreme Court is handling such cases, even though the constitution is very much clear that it is the parliament who will enact the law and adjudicate the water dispute between the states, and how it could adjudicate it through setting up the tribunals. And who will set the tribunal? It is the president who will set the tribunal. But still we are seeing that this Supreme Court is getting involved in it. And now we will see what are the problems. As we are discussing it now, let's see what are the problems with these setting up the tribunals. Let us have a quick look at it. Let's see what are the various issues coming up after setting up these tribunals. First, the major issue is the president's delaying the setting of the tribunal. First issue is that the president itself is delaying the setting of the tribunal. The first Interstate Water Dispute Act of 1956, it was set up, and president under this Interstate Water Dispute Act 1956, they have to set up the water tribunal with respect to the Kaveri river, but it was set up very late. So what is the first issue with respect to that? The president's delay in setting up the water tribunal. And the second issue is, one tribunal per dispute. So this is also one of the issues. First, it will constitute, for example, if there is any dispute with respect to various rivers, then the cycle will revolve. First, this center will come in, they will try to negotiate, then they will form the tribunal. So there it leads to the delaying of the case. Then when the tribunal will be formed, it will lead to the delays of the cases. So if there would have been a common tribunal, and under this common tribunal, if there would have been various branches, then it would have things would have been much easier. So this is also one of the reason for per dispute they have to set up the tribunal. It in a way delays the whole process. It in a way delays the justice. And the third, there was no time limit under which the tribunal has to decide over this matter. There is no time limit under which the tribunal has to decide the solution to it. So these are the issues with respect to the interwater disputes, which are sorted under Article 262, which the Parliament has the power to adjudicate under this matter by setting up the tribunals. But there are various issues. The first, delaying in the tribunal. Second, one dispute, one tribunal. Then the third is no time limit within which tribunals have to give the decisions or awards. So with respect to this, Parliament, the politicians, they are very much aware of it. And finally, the cabinet approved the Interstate River Water Dispute Amendment Bill 2019. What they amended? The cabinet approved the Interstate River Water Dispute Amendment Bill of 2019. So what were the provisions of this bill? Some major provisions were: one tribunal, there would be one common tribunal tribunal, and under this tribunal there would be various branches. For example, if the case is in South India, then there would be the branch there. If the case would be in any other place, there would be various branches under these tribunals. And also in this there was another provision that there was they will have a definite time limit under which they will have to decide, they will have to give the decision. The time limit was very much defined time limit was also given. So for this for any case to go to the tribunals, first what they will do, they will try to negotiate. If the negotiations will not work, then the case will go to the tribunals. But this, unfortunately, this bill could not be passed because in 2019 the Lok Sabha dissolved and eventually the bill lapsed. So this was the bill which was brought in. Now there are demands that such bill should again be brought in the Lok Sabha and it should be passed, and this matter should be sorted in this way. So this is the cooperative federalism, how the states cooperate with each other, how the state and the center cooperate with each other in solving the various issues, in solving, in developing the nation as a whole. Now similarly, as we discussed the cooperative federalism, cooperative relations, now let's see what are the consultative mechanisms. What are the consultative relations between the center and the state in this regard, as they have these consultative relations too. Let's have a look at the consultative relations now. Consultative relations. Now, in the consultative relations, we discussed that, for example, we have various issues going on. The water dispute is not only one dispute which is happening in our country between the states. There are various disputes. There would be the various problems in the southern Indian states. There are various problems in the north Indian states. There are various problems in the northeastern states. There are various problems in the border states. So various issues are there. So with respect to this, what does the Constitution say under Article 263? Article 263 says, if the Parliament is satisfied, if the President is satisfied, it could, what he could do, then the Parliament could set up the interstate councils. They could set up interstate councils. They could set up interstate councils. Then they should develop, they could set up interstate councils where they will discuss what are the issues, what are the matters, and they would advise, the government to make up such laws which are beneficiary for them. So what does the Article 263 say? It says that if the President is satisfied, then he could say, set up the interstate councils. So what is this interstate council? What would be its composition? Its composition would be there would be PM, there would be the Union Minister, and there would be CMs and the heads of all UTs, CMs of all states and heads of all UTs. So it will function as a federal body. What will it do? It will look at the matters, what are the issues in various states, and it will convince the government that to bring up those laws which could sort out these issues. So it will be consultative in nature. It will consult, it will consult the state. The center will consult the states through the consultative councils. In this way, the issues would be sorted out. But there is also with respect to the interstate councils, there are issues coming up. Meetings of interstate councils are very much irregular, and also these interstate councils should have the adjudicating powers, but they don't have the adjudicating powers, and this interstate council should have been the permanent body, but it is not a permanent body. Interstate council, it is the statutory body made because of the law of the Parliament. So these interstate councils, what it will constitute PM, CMs, and the heads of the UTs, which will act as which will function as a federal body, and the center, there would be consultation will happen there between the center and the states. What are the various issues, and they would be sorted out. This is what Article 3, this interstate council comes through from Article 263. Now this is what the Constitution says, but there are some extra constitutional provisions too, which shows the center-state relations. Now let us see what are those extra constitutional provisions. For example, we have zonal councils. Zonal constitution does not define about the zonal councils, but we have these zonal councils. So let's have a look at the extra constitutional provisions. What are these extra constitutional provisions? Basically the constitution did not define it about it, but they still came up by the executive orders. Let's have a look at these. So by the law of the parliament, or constitution itself, it was not there, but they came, they were formed by the, by some statutory law. Let's have a look at it. For example, we know when we discussed about the State Reorganization Act. We discussed about State Reorganization Act. And in this State Reorganization Act, we saw that how states came in, how there were 14 states and 6 UTs, how they came in. What language was also the basis of the, for the language was also used for the formation of the state. So in this State Reorganization Act also there was the concept of zonal councils given. So let's create these zonal councils. For example, we have the northern zone, we have the southern zone, we have eastern zone, we have the western zone, we have the central zone. Let's create these zonal councils. So 5 zonal councils were created. 5 zonal councils were created in this, and these are these zonal councils. They are the statutory bodies. Why the reason for the creation of these zonal councils? Because in the southern states they have the similar kind of problems, in the northern states they have similar kind of problems, in the western states they have similar kind of problems. So this zonal council will be created. They will discuss over the matters, and they can then consult the government what are the issues in this zone, and those issues can be sorted out. So these are the zonal councils, and it came through the State Reorganization Act of 1956. So these are the statutory bodies. So similarly we have different issues in various zones. So with respect to that, to sort out those issues, these zones were created. So who will be the chairman of these zones? This is very much important for your prelims. Chairman would be the Union Home Minister, and who would be the deputy chairman? It would rotate. After time it would be in rotation, the CMs of each state, and also UTs are part of it. Please remember that UTs are part of it. And finally in 1992, another zone was created, which is zonal council. Another zonal council was created, Northeastern Council Act, by the Northeastern Council Act of 1992. Northeastern Council Act of 1992. Another zonal council was created, Northeastern Council. So it was created in 1992, and here 7 northeastern states are part of it earlier, and in 2002 Sikkim was also added. But what is the difference here? Who will be the what is the composition here? It is the governors and CMs and 3 members. They would be nominated by the president. And who will be the chairman? Chairman would be one who would be nominated by the president of the India. So these zonal councils, they are also they also act as the feature of the cooperative federalism or the consultative federalism here. Then we have after this we have another thing we used to have, which is that is the planning commission. So let's have a look at it, what this planning commission was. Basically we have the Niti Aayog now. So to understand the Niti Aayog, first we have to understand this planning commission. So we have to understand the planning commission. So what was this planning commission? What is the history of the planning commission? Basically it is Pandit Nehru. He got inspired from the USSR, because they had during the Great Depression in 1929, USSR was the only country who survived, who had least impact of the Great Depression. So when the Pandit Nehru saw what is the structure in the USSR, he saw that they have they have the planning system there. They have 10-year plans there. What he said, they have 10-year plans there. So Pandit Nehru thought, once we will get the independence, we will have the same approach in our country too. So we adopted the 5-year plans. We adopted 5-year plans. And who will plan this 5-year plan? It was the planning commission. Planning commission will plan this 5-year plan. The planning commission will plan this 5-year plan. And this planning commission, it was created by an executive order. It was created by an executive order. It is not a statutory body. It is not a constitutional body. It is extra constitutional body, which is an extra constitutional non-statutory body. So it was created by an executive order, and it will study what would be the need, what would be the plan for 5 years, what would be the focus, and within what time span we will try to achieve it. It will define the plan. It will define the targeted areas. What would be the targeted areas in these 5 years? Would it be agriculture? How much growth is targeted? It would be all done by the planning commission. And who will be the chairman of the planning commission? Chairman would be the PM. PM would be the chairman of the planning commission. But with this planning commission, there were various issues. There was least representation of the states. Least representation of the states were not represented, even if the states were consulted. But this consultation was not mandatory on the planning commission. And also, this planning commission was the non-constitutional body, and the constitutional offices like CM, they have to go before the non-constitutional body. So they defined it. They decided that we should get rid of it. It was the Narendra Modi who defined that we should get rid of it. And once he got into the office in 2014, the first thing what he did was to get rid of the planning commission, and it was replaced by the Niti Ayog. It was replaced by the Niti Ayog, and Niti Ayog is the best example of the cooperative federalism, because if we look at the structure of the Niti Ayog, we have the chairman, we have vice chairman, we have full-time members, we have ex officio members, we have special invitees in it. All CMs of this, all states are part of it, all lieutenant governors are the part of it. It is basically the federal body, and it is also created by the executive order or the government resolution. And the principal objective of the Niti Ayog is to act as the think tank of the government, and this advises the government what it thinks for the government, what are the necessities of the people of the particular state. It will advise the government to make up the laws, what are the necessities, and it will set up the targets, it will set up the various ranking system, and it will then rank the states how they had achieved those targets. So it advises the government, it creates the plans what they have to achieve. It will act as a planning commission, but with a different structure. So this is what the planning commission and Niti Ayog, how it was replaced by the Niti Ayog. The main purpose why we are discussing this right now, because we are discussing the cooperative federalism, how the center and the states cooperate through various mechanisms. First, we saw through how constitution leads for the cooperative federalism. Whenever there is any dispute, then how constitution reacts. Then there are extra constitutional ways also. Then there are statutory which are extra constitutional. Then there are by the executive orders, there can be the cooperation between the center and the state. There would be the cooperative federalism. Then similarly, we used to have the, we still have the National Integration Council. It was also created. What? National Integration Council was also created. And what was the major purpose of the National Integration Council? So to understand it, we have to understand what is the major threat to the integration. What is the major threat to the integration? The major threat to integration is the regionalism. Regionalism. For example, if the states they behave like regionals, they behave like that there are certain posts, they should be for, they should only for their people. We, for example, we used to have the sons of the soil. For example, target certain population. For example, if in Jammu and Kashmir, they will start targeting the non JNKs, non-residents of Jammu and Kashmir, those migrants of Jammu and Kashmir. This regional feature will appear. So to negate, to end this regional feature, this national integrated council, integration council was created. So in this way, in the national integration council, what would be the setup? It would be headed by the PM. This national integration council headed by PM. It would be there would be the chief ministers, lieutenant governors from the UTs, and journalists. Other think tank will also be the part of it. So they will analyze what are the various issues happening right now, and what can be the solution for that, what can lead to the, what can harm the integration. For example, there are religious tendencies in particular state, so how it can be negated, how it can be reduced. So this was the purpose of it. But from it's, if we look at it, the last meeting was of the National Integration Council. It took place in 2013, and from 2013 onwards there has been no meeting of the National Integration Council, and it is believed that we should again start the meetings of National Integration Council, because there are various issues coming up. For example, we have the language issues in the South Indian state. So there are the time has come when there is again the need of the meetings of the National Integration Council, so that this tendency of regionalism will be reduced through proper consultation, through proper cooperation between the center and the states. So these are few features which are in constitution, or which are by different laws, which lead us towards the center state relation, the cooperation between the center and state. Sometimes the center will force state to do it for the benefit of the national interest, but sometimes it would be very much consultative in nature, it would be the cooperative in nature, and the aim is to grow as a nation. So this is about the administrative cooperation. Now we discussed in our last class, we discussed the legislative cooperation. In today's class, what is related to your prelims, in today's class we discussed about the cooperative relations, administrative or executive relations too. Now what we are left with, we are left with the financial relations. These financial relations, this financial center state relation, we will take up in the economic classes. I know you would be with me, so everything would be cleared. As I had told you, every concept would be cleared here, so don't worry about that, and just stay with me. Now this is about the administrative and the legislative domain of the center state relation, and whatever related to prelims is important for you, which could be asked, we had discussed in a very detailed manner. Now let us see what is the mains perspective of it, how this question, how a question from it can be asked in the mains exam. So basically a question which can be asked is about the evolution of the federalism. So let's try to understand that how federalism has evolved in India from the day we enacted the constitution. So let's try to understand that one by one. So the topic is federalism now. Federalism. So topic is federalism. So what does the constitution say about the federalism? Does constitution mention federalism? The answer to it is big no. Constitution nowhere mentions the federalism. But why Supreme Court says the federalism is the basic structure of the Indian constitution? Even though federalism is not mentioned nowhere in the constitution, but still Supreme Court says the federalism is the basic structure of the constitution and it cannot be violated. It is very much evident from the various acts in the Indian constitution, from the days of, from the various relationships which we discussed. It is very much evident that federalism is the basic structure of the Indian constitution in the normal circumstances. But if there is abnormal circumstances, then the situation would be totally different. Even if we look at the Article 1 of the Indian Constitution, what does Article 1 say? Article 1 says India, that is Bharat, shall be a union of states. India, that is Bharat, shall be the union of states. So it does not mention the federalism. So let's see how we evolved the how what kind of federalism India have. We had discussed it. From last 25 4 lectures we are discussing it in different directions. Now the time has come. We will now give it the proper shape. How the federalism has evolved. How the federalism is seen. What is basic requirement of the federalism? The basic requirement of the federalism, if we will see, it is the sharing of the powers. You share something with two or more units. So what would be there? There would be the center, there would be state, or there would be the local bodies. Even though there are some experts which say that the local bodies don't come under the federal structure, they are the they don't come under the federal structure, but there is a debate over it. But let's assume that there are states and there are centers, and this power is distributed between the center and state. And who distributes this power? It is the constitution gives separate power to center, constitution gives separate power to states, and constitution gives separate power to the local bodies. So what was the need? What was the need of the, even though Indian constitution does not mention of the federalism, then what was the need that we adopted the federalism? What was the necessity here? The necessity was, look at the geography of India. If we look at the geography, we have the vast area in our country. We have vast area. So to administer this vast area was not a piece of, not a walk in a park. It is not a walk in a park for the center. So definitely there was a need for the sharing of the powers. So definitely there was the need for the creation of the states with which the powers would be shared. So for the administrative convenience. First, for the administrative convenience, there was a need for the federalism. Second, look at the cultural diversity of our nation. The cultural diversity, it is very huge, and we cannot ignore. We have the diversity in tribes, the way people look. We have the diversity in race. We have the diversity in languages. We have diversity in religions. So there is huge diversity in our nation. So definitely there is the need that this diversity should be respected. And how it could be respected? If some autonomy is given to them in different ways. So there was the need for the federalism. So cultural diversity, it led to the federalism. And the third most important thing is that if this federalism was not there, if the linguistic federalism was not there, if it was not there, then definitely it would have led to the breakdown of the state, breakdown of the country. We have the example of the Pakistan. Even though Pakistan, it became on the name of the religion, but it could not sustain because the federalism was not enjoyed there. We are seeing issues in the Pakistan because there is not that good federal structure. So definitely to sustain as a nation, there was the need for the federal structure. So to hold together, there was the need of the federal structure. So for our own survival, for the survival of the nation, it was necessity that we adopt the federal structure, with this with the centralized tendency, we adopted the federalism, but it is very much different from the world's federalism. We have the centralized federalism. We have the power center is more strong because they have the resources, they have the ability to take the decision. The army is within their control, so that is more strong. And then we call it, we have the centralized federalism. Why? Because of various reasons. Look at the Article 3. It gives the ultimate power to the parliament. Look at the subjects in the union list. Maximum number of subjects are in the union list, 97 subjects. Look at the residuary powers, they are with the center. Look at the office of the governor of a state. Who he behaves like a center, he acts like an agent of a center. He checks the balance of the state, whether the state is going wrong or not. Then look at Article 356 during emergency. Look, we have this single citizenship here, we have the single constitution here. Look at the Election Commission of India, similar for one for the state elections as well as for the central elections. But here we can give this one of the reason why local bodies are not called federal, because for their election we have a separate body which is the State Election Commission. So this could be one of the reason. And then look at the audit mechanism. We have same audit mechanism, centralized audit mechanism. So definitely we have the centralized characteristic of the federalism. But this federalism, according to some experts, it is very much accidental in India. This federalism, it was not envisaged by the makers of the constitution in this way what it is right now. So it is very much accidental in nature. Now let's see what are the various stages of the federalism in India from the history. What are various stages of the Indian federalism? Let's have a look at that now. I believe that this topic is very much boring. It might be very much boring for you, but it is very much important for you to crack the prelims exam, because questions get asked from this topic. Whatever we had discussed till now, please make the notes of those important points, and they are very much important for your prelims preparation. So let's see what are the, coming to our discussion again. Let's see what are the various how the federalism evolved in India. It is said that it evolved in 4 phases. As the Kapil Sibil says, it is the accidental federalism. So let us see what are those 4 phases. The first phase is one party federalism. One party federalism. So what is this one party federalism? What is from 1952, from the day constitution came in, till 1967, till the till 1967, once Nehru died, then the situation started to change when Indira Gandhi came in. So what was the structure of the federalism at that time? One party. And it was a time when at the central level there was Congress, at the state level there was Congress also. But this Congress was very much different from the Congress we have. We have strong representation both at the center and at the state. And the head of the Congress was Nehru, the most popular leader. He was the strong Democrat. He was strong Democrat, and he would not do anything silly with respect to that. So it is believed that the best federalism, the peaceful federalism, if we had seen, it was in this time period. So it was in his time period. Even though we could see it was ruled by the one state, one political party, whole country was under one political party. But at the same time, Hindi was not imposed in the country. Hindi could not be imposed in the country because of the regional politicians. They agitated, being from the same political party, but they agitated. They looked for their interest, and the center also respected them. So it was very much clear, it was very much clear that, strong regional leaders of the Congress at the regional level and the center, there was good cooperation between them. They respected each other's domains, and they respected each other's demands. So this time period from 1912 to from 1952 to 1967, it is called the first phase of the Indian federalism. It is both from the center and state level, it was one political party, but the respect was different. The cooperation was at the best. The only thing which is a black spot on this federalism is with respect to the president's rule in Kerala. President's rule in Kerala is the only black spot on this federalism. So otherwise, it was the best one. We have the linguistic federalism at that time. The states were formed on the basis of the language, and Hindi was not imposed. The extension of English was added into it. What was the reason? The reason was that the regional powers were strong, and there was the best cooperation between the center and the state. Then the second phase of this federalism, the second phase, it was from 1967 to 1989. It is a time when the drift started. Congress, in this time the Congress split in 1969. The Congress split into the into Congress Indira and Congress O, and the Congress split. And it led to this. Then in this time period, the Congress party started losing the regional leaders. Congress started losing regional leaders, and the at the state level, the regional powers started to come into the existence. So Congress lost dominance in the state, but at the central level, it was one party, and it was the Congress which was the whole superior at the central level. It was the one party, but at the at the lower levels, at the state levels, the Congress lost its dominance. So the regional political parties in states, they came into existence, and it led to various clashes. For example, when Indira Gandhi imposed, she imposed emergency. Then when Janta government came in, Janta government replaced her, and we saw that in 9 states the emergency, the president's rule was imposed, and then elections there. Similarly, when she came back, she did the same. So conflict started, and similarly the conflict in various other states. For example, in Assam, the illegal migration; in Punjab, the Khalistani issue started, and similarly militancy in Kashmir. So in this phase, various issues started, and because of these issues, because of the diversion of the regional political parties at the state level, it led to what? It led to the bargaining federalism. Bargaining federalism originated in this phase. Bargaining federalism originated in this phase. So the states and the center would bargain in. The states started to bargain with the center. If you want this from us, please do that. So the bargaining started in this phase. It was in the 19 it was between 1967 to 1989, where there was one strong center, center, strong political party at the center, and at the regional level, at the state level, there were various regional political parties. So in this phase, the bargaining started, and in this phase, the various commissions were created. For example, Sarkaria Commission, which will look into the matters what do the states want, which was created by the Rajiv Gandhi, in his time period. So then the Sarkaria Commission came in, and it would look into the issues of the states. So similarly, then the other, the center started to compromise with respect to states. For example, with Assam, the Assamese Accord was signed by the Rajiv Gandhi. So this is how the bargaining of the states started in this second phase. Then there is third phase, which is multi-party federation. The third phase of the federalism in our history is the multi-party. Now the third phase of the federalism is of the multi-party federalism. So under this, when there was no strong center, when there is no strong center, then the center has the political parties, the majority, in the election, the party which has the majority, they have to rely on other political parties to gain the power to be in the government. So for that, there would be lots of bargaining. They have to give something, they have to lose something. So this phase of the multi-party federalism, it is called the best phase of the federalism in India, because in this phase the states gained the maximum powers. The states gained the maximum powers because the center has to rely on the other political parties. For example, we have the NDA one, then we have the UPA one, we have UPA two from 2004 to 2013. So this phase, it was at the central level and at the state level, there were multi parties. They were coming together, and to run the government, you have to satisfy them. So that's why you have to strengthen the state governments, you have to give them more powers, and it is called the best phase of the federalism. This is called the best phase of the federalism, and it lasted from 1989 till 2013. And in this phase, various reforms were brought in. For example, LPG reforms of 1991, and similarly, similar, the LPG reforms were brought in. Then nationalization of industries was ended. It was then various judicial safeguards were given. The federalism in this phase became the by the SR Bombay case, federalism became the judiciary declared that federalism is the part of the basic structure of the constitution. And in this phase, itself the 73rd and 74th constitutional amendment came in, where it gave the constitutional status to panchayats and municipalities. So this was the third phase of the federalism. Now the fourth phase. And now the fourth phase, as it is said that the history repeats itself. Now we are going back to the what we, from where we started, from the beginning, from the 1952, where we have the strong center, for in the form of BJP. We have the strong center, and we are seeing in 22 states there were BJP government from 2014. So what we are going to do, it is the BJP led federalism. From 2014 onwards, there is BJP led federalism, where we have the dominant political party. We have dominant political party at the center, and in the same way at different states, in the majority of the states, in 22 states, it was ruled by BJP. So we have the dominant political party in the country right now, which is governing at the state level and at the central level. So the federalism is again coming back, and in this phase the government has done tremendous job. For example, they came up with the GST reforms, where there to avoid the double taxation, all the indirect taxes were brought into the GST, and then also in the GST council, if we look at GST council, the representation, the voting, for example, there would be the union finance ministers and the state finance ministers. What would be the voting, how much your vote will cost. For example, it was 1/3 of voting was given to the union finance minister, and 2/3 for the state finance ministers. Then in this phase only the Niti Aayog came in. After that, the finance commission, it talked about the distribution of tax revenue from divisible pool of taxes. Distribution finance commission, it talked about the distribution of tax revenues from the divisible pool of taxes. Earlier it used to be 23%. Now it is 41%. Before J&K became UT, it was 42%. So this much, these things had been brought out in this. So it has in a way further strengthened the federalism. But at the same time, there are various conflicts in this forum, in this federalism. What are these conflicts? Let's have a slight look on it, and we will understand the federalism, how it evolved in India. So what are the conflicts? For example, promotion of Hindi at the expense of English. This is not liked by the South Indian states. So there is often quarrel between the center and the state with respect to that. We have new education policy, the quarrel on that. So similarly, limits on the borrowing money by the states. How much a state can borrow, there are limits on them. The states will go for the center will put limitations on them, how they will have to open the market. Then we have the center is going for one nation one ration card. This is also one of the allegation against the federalism. The center is going for the one nation one election. This is also one of the way it is against the federal structure. Similarly, the jurisdiction of BSF has been increased. Earlier it used to be 15 kilometers away from the borders. Now the jurisdiction of the BSF has increased to the 50 kilometers. So in a way it is going to impact the center-state relations in this way also. Then also the jurisdiction of CBI, and in one case the Supreme Court said that the CBI is acting as the caged parrot. It is saying what its master is saying. The master is the state government, the central government, and it is alleged that the central government is misusing the central agencies like CBI, the ED against the politicians who belong to opposite political parties. So definitely there are various allegations, but at the same time the federalism has seen the strength, but at the same time there are various issues in the present federalism which are showing that there is deviation from the federalism. There is much unitary strength, or we can say there is much one party strength. Whatever they want, they are trying to achieve it. So this is also one of the allegation. Then similarly, this is the how by accident we had evolved in 4 stages. We discussed that. Similarly, the constitution says that we are asymmetric federal. We have the asymmetry in the federalism. What is this asymmetry? Different states would be treated differently. For example, we used to have Article 370 in which Jammu and Kashmir was treated differently with compared to other states. Similarly, we have various other articles like Article 371, which will treat Gujarat and Maharashtra differently. Then we have various subclauses of it that we will see here. For example, Article 371 special provisions with respect to the states of Maharashtra and Gujarat. The article grants special responsibility to the governor of Maharashtra and Gujarat in the establishment of development boards, in equitable allocation of funds and equitable opportunities. So this Article 371 is it specifies special provisions for the Maharashtra and Gujarat, which shows that there is no symmetry in these states. There is the difference in that. There is asymmetry in that. Similarly, we have Article 371A for the Nagaland. No act of the Parliament regarding religious or social practices of Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law or ownership and transfer of land and its resources shall apply to Nagaland unless the state legislative assembly by the resolution so decides. So here, what is important for your exam? Please remember what are the articles and to what state they are related to. So this is Article 371 related to Nagaland. Then we have Article 371B, Assam. It is related to Assam, provides for the constitution and functions of a committees of the Legislative Assembly of Assam, consisting of members elected from the tribal areas of Assam. Then we have Article 371C. It is related to Manipur. Then we have Article 371D and E, Andhra Pradesh and Telangana. We have Article 371D. It defines further them. Then similarly, we have Article 371F. It is for Sikkim. We have Article 371G, it differentiates Mizoram. We have Article 371H, it is about the Arunachal Pradesh. Then we have Article 371I, it is about Goa, and Article 371J, it is about the Karnataka or Hyderabad Karnataka region, Kalyana Karnataka region. So this is how this shows that there are certain safeguards given to different states, and it shows that there is the constitution, our constitution is the federalism in our constitution. It is not symmetric, it is asymmetric too. It is not planned, it is accidental too. It is not something which was enshrined by the makers of the constitution. It got right now what constitution, what structure of the federalism we have, it got evolved. It was not always there, it was not enshrined, it was very much accidental because the situation is demanded and we evolved like that. And this is the beauty of Indian federalism. So with this, I hope I was able to make you understand all these concepts in a detailed way. If there is any confusion, please do write in the comments. And about this, we will prepare in the notes. We will include everything for your understanding, because here it was the necessity was to discuss these provisions, which is important, and these are very much specific to your prelims exam. So please look into our notes. We will discuss these in detail and with the example questions. So with this, we complete our today's discussion. I hope you would have liked the video. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with me. Thank you very much, and have a nice day.